Hello everyone. Welcome to all the esteemed guests and a very warm welcome to our faculty and teacher and guru for today, Shri S.S. Naganand sir, Senior Advocate, Karnataka High Court, Vice President, Bar Association of India, and so much more that I want to say about sir, but sir has very humbly restricted me with express instructions to limit my introduction. So, with that respect, sir, very, very warm welcome to you. And also, but irrespective, I'll just mention a few things about sir so that there can be context for every single person to have more and more information about sir. Irrespective, sir does not need any introductions. Sir is beyond all of that. But I will still mention, I request everyone to kindly just mute their mics for the time being. We'll have a detailed question answer session with sir towards the end of the class. So very briefly about sir, sir is a LLB gold medalist from Renukacharya College of Law, Bangalore University. Sir is a qualified CA also with national merit rank. Sir started his practice in 1981 and was designated a senior advocate in 2003. Sir is also partners at Sundara Swami Ramadas and Anand Advocates, which is known as SRA Advocates. Along with this, sir will today be speaking about efficient research, methodological options and solutions, and whatever opinions sir wants to express on that particular topic. And with that, I very humbly and warmly welcome sir, and I request sir to kindly take over the class.
Thank you, Kesha. It's a pleasure to be with young people and some old people also on Sunday morning. A small correction, the firm of Sundar Swami Ramdas and Anand was something which was founded during my father's time. And we have moved along, and I have now a law firm called Just Law. And that's the one which I now run. And that's a practice in which I have. We have offices in Bangalore and Delhi, and practices there in the Just Law now. Okay. The topic given to me is somewhat unusual for a lawyer's meeting. The question is about what are these efficient research methodologies? Now, before we go into research methodology, I think we need to look at some aspects of the profession. You know, all of us know, or the profession of law, they say is a very demanding profession. They say law is a jealous mistress. And law is a profession based in knowledge. It is a knowledge profession. And they also call learned profession. Therefore, we address each other in court as my learned brother, my learned senior, learned judge, and honorable judge. These kind of expressions are used in courts to constantly remind us that we are a body which is of educated people, the privileged ones in this country, and everybody assumes that we have knowledge. Now, another thing we need to not forget is that we are a service industry. Now, service industry is one which provides good and efficient service to a person who wants our service. The consumers of justice, somebody wants justice. How does he go to the court? He comes to the lawyer. And therefore, it is the lawyer's duty to understand his problem, analyze it properly, and thereafter give him the right advice. The same thing goes with other professions like medical profession. If somebody goes with an ailment, the doctor will look at the patient, examine him or her, find out what tests are to be done, prescribe the tests, get the tests done, look at the reports. Thereafter, try to find out what could be the cause for the problem, and then resolve the issue by giving appropriate treatment or procedure. Now, in the same way, in the legal profession, if you have to understand the problem, you need to know the law. Now, I remember when I studied law, I did a part-time 3-year postgraduate course. The class was from 7 a.m. to 10 a.m. because after 10 a.m. I had to go and attend to my duties as the article clerk when I was doing my chartered accountancy. So this 3 hours time, and there was an evening batch also, so you could opt for the morning or the evening batch. Evening was 6 to 9. The total number of students in my class were about 140, 130 students. But to your surprise, hardly 20 people used to attend. Not more than 20 students were attending the lectures. Attendance was not even taken. It was just marked. And lectures were given by several eminent people who were practicing lawyers. But what we found was that the subject being so deep, so vast, we had 6 papers in each year. So in each of those papers, there was 3-hour exam. So we could hardly touch, for example, if you take the Civil Procedure Code, I mean, the code is so huge and so complex that after so many years of practice, every time I get a problem under the Civil Procedure Code, I have to go look at the sections, look at the case law, research something. Of course, we have some general idea, but it is important for us to keep ourselves abreast. So what the point that I'm trying to make is that this subject is extremely vast. Not only that, the subject it got so many branches. Now, in the good old days, I remember there was called an LMP doctor, licentiate medical practitioner. He was not a graduate. He was given a small kind of a diploma and they could practice the medicine. Of course, later it changed and now you have the MBBS. It's a 5.5-year course plus you have a 1-year internship. Then you are entitled to practice. But how many of us would want to go to an MBBS doctor now if you have a serious ailment? We would certainly want to go to a more qualified person. We would like to go to somebody who has at least an MD, if not a DM, which is a doctorate in the field of medicine. We would like to go to somebody who's designated as a consultant or a senior consultant and take his expert advice. Now, there also, if you have a particular problem, you would go to the specialist in that field, not go to somebody else in some other field. Now, if a gynecological problem is there, you don't go to the orthopedician, you go to a gynecologist. So the thing is, this area of specialization is becoming, smaller, narrower, and deeper also. So the subject is extremely vast, and the branches of law are, very, very wide. For example, now I know many persons, many years ago, there was a very senior lawyer who used to practice on the taxation side. In the initial years, I also did fairly large amount of tax work. So one day he telephoned to me and said, Naganand, my client has come. He's my regular tax client. He wants me to file a caveat. Honestly, I don't know how to file a caveat. I've never filed a caveat. Can you please send me a format of a caveat which you use and tell me what the procedure is? Mind you, this gentleman was the senior standing counsel to the income tax department, is very, very successful practitioner. But he had the humility to tell me that he had never handled it. More recently, another very senior lawyer who's a designated senior advocate, one day he said, I'm in Bangalore, can I come to see you? I said, yes, most certainly. So he came, met me, and he said, this client of mine has a problem in land acquisition. I've never handled a land acquisition case, so I didn't want to advise him. So I want your help. I will, take some class from you and I'll send the client so that, I know a little bit and you handle it. See, what I'm saying is that we cannot be the masters of every branch of law. So these branches of law are another thing which gives you kind of a challenge. Now, another thing is law is something which goes on changing. Now, every day there are changes in the law. You've been reading the newspapers, there's so many archaic laws are repealed, some new law is made. They make a new law and find a loophole in it. So the next Finance Act will have this year's, the budget book, usually it used to be about 150 pages. I think this year the book runs into about 400 pages or so, because there are so many changes that are coming. And recently I participated as a panelist in the Institute of Chartered Accountants when the discussion on budget came. And the volume of documentation and information that is coming towards us. And if you are a practicing lawyer on this branch, you have to keep yourself abreast. So you have the next problem of new law. Like, there are so many new laws that are made. Now you have the law relating to money laundering. It's of recent origin, and we've all been seeing it. How many cases are coming up under that? How different agencies are handling that. Like this. Now you have also law relating to real estate development regulation. That's a new legislation. So you have new laws, amendment to old laws. Added to all this, you have the law of precedent. And the law of precedent is that if the case is decided earlier, that same will apply and will be binding. And Article 141 of the Constitution says decisions of the Supreme Court are binding on every authority in India. So you need to know the law of precedents. Now, all these are the sources of law. Where do they come from? Now, if you analyze them, where do you get all this from? They all have to be in written form. So there is some books are available. Bare Acts. I remember A.N. Iyer, an old publication from Madras. Every year they used to publish A.N. Iyer's Direct Tax Laws. It was a black color volume. That year's Finance Act, with all changes in the Income Tax Act incorporated for that year, because the changes are so many. Every year he had to come out with a book, and it was a very popular book. I used to buy it and refer to it quite often. So what I'm saying is books, physical form. Second, law reports, because we have precedents. So you need to read law reports. Now, there are so many law reports. I remember reading Excise Law Times, Income Tax Reports, Sales Tax Reports, AIR, All India Reporter, Karnataka and other states, then SCR initially, then Supreme Court cases, SCC, then some specialized law reports like excise and customs cases, company cases. Now, like this, company law journal, all these. Then later we got scale. And then prior to all this, we used to get cyclostyle decisions to the Supreme Court from the Supreme Court Bar Association. I remember still. Now, you see, these are the various sources when you get all this information. Of course, fortunately, in today's day and age, you don't have to depend on all of this. You can just manage with a small smartphone and your connectivity to various databases of SCC, Live Law, India Kanun, so many of them. So you have all of them available. Now, do you stop there? No, you cannot stop there, because you have to then go to legal literature. Now, we all know India Penal Code, Ratan Lal, Chaturvedi Pithisarya and Palkiwala Income Tax, Ramaya Company Law, Buckley, Pennington Company Law. These are leading texts in that respective field. So you have to have this interpretation of statutes, Justice G.P. Singh's magnum opus. Then if you go west, it is Bennion on interpretation of statutes, Kim Lewinson on interpretation of contracts. Now, like this, there is, Roland Barrows on interpretation of instruments, very famous book, very ancient book. Now, what I'm saying is all this resource is available. So if you want to become legally, relevant and up to date, you need to access all these things. I still remember a former judge of the Supreme Court one day telephoned to me to say that, my former client came to meet me. This gentleman is now retired. And he said he wanted some advice on this particular field of law. I told him I'm not competent to advise him. I said, why? He said, no, you see, I've stopped becoming a judge some years ago, and I've not kept myself abreast of the development. So I feel diffident in advising him. So I asked him to meet you, and you please, guide him and give him the correct position. So the thing is that if you don't update yourself, then you're going to be irrelevant. Now let's look at how do you update your information. In my chambers, I have a system where I've asked every associate, we have about 25 of them, every associate should read at least one decision a day of the Supreme Court. At least one, I said. Okay, you could read more. But is it so difficult to read one decision a day? And once a week, we have a meeting where all the associates have to present any one case which they have read. Give the facts very briefly in 3 or 4 minutes without reference to any notes. That give the citation. They have to tell us what the point of law is. What was the law that was laid down in that decision? They have to do it in 3 minutes or less. Like this, everybody gets a turn. I also chip in and say, I read this decision. This is what it is, development of the law, things like that. Now, how do you keep yourself abreast? So the only way in which you can keep yourself abreast is to read law reports. Of course, now you have Live Law, which gives you a prompt every day. And it's not very expensive. So I think most people have subscribed to that. Then you have many databases which are free. Recently, the Supreme Court has opened out its entire archives and all decisions to anybody, free. You don't have to pay for it. The high courts, including our Karnataka High Court and Delhi High Court, all of them opened their website. So you can go and search and you can look at decisions, you can read them, you can print them, and you can, cite them from there directly. All this facility is available. Now, in the past, today, this is so easy. Now, look at some 25 years ago. I remember All India Reporter used to publish a book called the Quinquennial Digest. That means for every 5 years, all reported decisions analyzed under all the central statutes. So you take any central statute, and under that, each section by section, if there is a case reported, it would be put in that digest. So the 5-year digest. It used to come at its own speed. So far as the state laws are concerned, there's no such facility available. because none of the law reporters thought it worthwhile to do any exercise like that. So there was no methodology of finding out which state law has been subject to interpretation and decision. The Bar Association used to publish the annual survey of Indian law, which was a very good publication. It's still on. They invite leading authors to write on one particular subject: company law, taxation, constitutional law, like that, labor law. And each article analyzes all the decided cases in that field in that year. Now, these were the sources of information that we are getting. So if supposing you're arguing a case and you want a case law for a proposition which you want to canvass before the court, courts generally ask, this is a very old section, is there no decided case on this point? So then you need to look up. How do you look up? So you need to look at the Quinquennial Digest. Then from there, you take out the citation, take out those books, look at those books. And these digests also used to give you a small key which said that this particular case is referred in the following judgments later. This is dissented. This is overruled. Some other court has not agreed with this. All these notations would be available. So you look at all those things and then you find out. Now, the way research was being done in the past and today is undergone a sea change. This SCC online, which now includes many tribunals, including the High Courts, the Supreme Court, everything, is a fantastic tool. You can just go there quickly, put some catchwords, start looking at judgments, download judgments, you can read it, and then you can annotate it, and you can then follow the cases which were followed in that, and go forward and come to some conclusion as to which are the cases on the point. Just few days ago, we were arguing a case before the Supreme Court. The court stated a proposition and asked the other side, this seems to be the proposition. How can a grandson file a suit for partition in the lifetime of his father? That's the question. Judge felt that he can't do it because that is a case where the grandson had filed a suit against the grandfather, father and uncles and other people for a partition of a suit of a property on the premise that it was a joint family property. Of course, there's a different point in that. What I'm saying is the judges posed this question. The counsel who was arguing was foxed because he never expected that this question would come from the court. It was incidentally arising in the High Court, this question. I had argued in the High Court, but the court didn't decide that issue in fully. But the Supreme Court entertained this doubt. So since he was not very sure, the judges looked at us and said, well, what do you say, on this proposition? Can a grandson file a suit? So luckily for us, we had done a fair bit of research. And we found a very old decision of the Bombay High Court, of a full bench decision, in which the minority view was that the grandson can file. The majority view was that the grandson cannot file a suit in the lifetime of the father. So immediately I told the court, there is a decision for full bench of the Bombay High Court, which is of 100-year vintage. And probably, that we have to do some research to find out if that decision is commented, referred, reversed, or some other High Court has dissented from that, disagreed with the view that is expressed there. What I'm saying is, this research is something which is important in the course of arguments before any superior court. Of course, when you're practicing exclusively on the subordinate courts, you don't have to, you don't need this up-to-date information, because as we all know, the law of precedence is what you cite, the judge will consider. But to be an efficient lawyer, you need to look at that also and make sure that your knowledge is up to date. I'll give another example. As we are arguing a case, it was to come up the following day. And that night, when I read a prompt from Live Law, I found a decision of the current Chief Justice of India exactly on the point. And I immediately, told my office to take a printout. My junior took it. Next day morning, we went and cited it. And the judge was looking at me. He said, my God, this decision is yesterday and you're citing it today? I said, yes, this is the state of the legal knowledge updation that is taking place today. So if I had not read Live Law, if I had not read that decision, means even if I had seen the prompt, I had to take the trouble to open the page, read that judgment, look at what the facts are, then decide whether this is important, then take a call that we have to cite it. And that's how law develops. Now, the thing is, how do you carry out this methodology of research? I think I'll only give 2 or 3 tips. First thing is, we must have the urge to learn. We must make every effort to keep ourselves abreast. There's no substitute except to read updated law reports. That's one. Secondly, you must know what are the books available on the subject. I just now narrated. I don't know how many of you would have heard of the greatest American books on law. The Oliver Wendell Holmes wrote a book in 1881 called The Common Law. It's still a source which is even quoted even today. Justice Benjamin Cardozo wrote a book in 1921, Nature of Judicial Process. 1921. In 1930, J.N. Frank wrote Law and the Modern Mind. Now, like this, Posner wrote in 73, Analysis of Law. We all are familiar with Lord Denning from the United Kingdom, who wrote a number of books, Leave from a Library, A Rule of Law, Due Process of Law. Number of these books, they're so simple books. They're so clear in their thinking, such lovely language. Like this, you have number of leading textbooks. Now, if you want to look at torts, there are at least 3 or 4 decisions, books on tort. Now, this source of information, and this, for example, if you look at law of contract, then you're looking at Anson's law of contract. If you're looking at company law, you have Palmer, you have Buckley, you have Pennington. Like, these are the leading texts. I still remember when Chief Justice Venkatachalaya was presiding over benches in the Karnataka High Court, many times he would refer to some book. And if the librarian said, sir, we don't have that book, he would say, send him to Mr. Sundar Swami's office. You will get this book and you will get the latest edition. That was my late father. So our library was known to be the latest and the most updated library, even 40, 50 years ago. And the leading books like Halsbury's Laws of England, American Jurisprudence, Corpus Juris Secundum, all these were all standard books in a good library. Now, if you have a good library, first you must know, in fact, now, whenever new juniors come in, I tell them first, before you start doing any work, please walk around the entire office. We have an office which is spread over something like about 5,000-6,000 square feet. Go around, see the library, please understand what books are where, what are the books that are available. If you don't even know that there is a book like that, how will you search for it? And of course, you have to cultivate your memory. If you read leading cases and they are of great importance, now if you ask any civil lawyer, what are the leading cases relating to grant of temporary injunction? What are the principles for grant of temporary injunction? Of course, everybody will tell you prima facie case, balance of convenience, irreparable injury. These are the 3 things which one has to see. But which is the case which says that how this should be interpreted? Famous decision of Wander versus Antox, Karnataka decision of Purna Investments, Gauri Shankar Swamigalu judgment of Karnataka. All these are leading judgments which are day in and day out cited. So you must know the leading cases. For the advocates on record examination of the Supreme Court, they have prescribed 100 leading decisions of the Supreme Court. It's available. You can just download that list and see it. How many of us have read those 100 decisions? It starts with Keshavananda Bharati. How many have read Keshavananda Bharati? It's a magnum opus judgment which runs into some 1,000 and odd pages of printed matter. We should be able to read that entire judgment and assimilate it in less than 1 hour. How can you do that? You have to be quick in reading. You must know what to read. You must know what to skip. So research involves all these things. If you don't do all these things, then it is not possible for you to be an updated lawyer. So if you want to be an updated lawyer, then you need to do all these things. Now, today the tools are there. You have artificial intelligence. I think all of you have read about ChatGPT, which is now in a position to churn out an article on a subject which you just ask it to write. If you say law relating to eminent domain, it may give you an article of 5 pages or 6 pages, which gives you the history of the legislation. These are artificial methods. But I think the only remedy available is a good, efficient library, the will to read, and before you go to bed every day, if you have not read at least 1 or 2 decisions, you have wasted your day as a professional. Because if you are not up to date, it's not possible. Now, what I mean by up to date is, the new finance bill is now introduced in Parliament. Right. Next day, your client comes and asks you, there is sir, there's some change is made. So, what is the correct position? So if you don't know it, If you have not read it, if you have not studied it, how can you answer that question? The same thing with so many other fields of law. A new decision comes, that decision says that, this line is not correct. You cannot go through this procedure. And a client comes to you, you have not read that decision. Then how do you make out your mind and give him an advice? So research is very, very important. And the way you need to do it is a very systematic, organized manner. Also, it would help if you maintain your own system of noting decisions which you read. I have a system which in a diary I write down under different dates. I have a particular methodology of writing it down, where if you ask me a particular point, cases which you have seen, which you have cited, leading authorities are immediately available. We can just take it out in a jiffy and give it to you. So research means first reading, then assimilating, then putting it in some order. Now, lastly, I would like to say that, all knowledge is going to come to your aid sometime. There is no knowledge which goes waste, especially if you have cultivated a good memory. Fortunately, my memory is still somewhat all right. And I remember a large number of decisions with reference to the name of the parties, who are the judges, what was the point involved, and what was the decision. I don't remember the exact words, but this broad thing is available. So the minute we are discussing a particular point, those decisions can just come flash to your mind. Then you have to take the trouble of pulling out the book. You have to take out the book. You have to read it in the context of the problem which is in front of you, analyze it, and then decide whether this is useful, not useful. How do we cite it? Should we cite it? And what would happen if the opposite side cites it? That also you must know. You must not only know cases in your favor, you must know the decisions which are against you. Because the minute the opposite side cites something against you, you should not be foxed. So how will you know that? You're going to research. You're going to find out what is the case that's going to be cited against you. And in the notes that you prepare, you have to put down cases which we are going to cite, cases which are probably going to be cited by the other side. If so cited, what is the answer we're going to have? That's the only way in which you can, complete your research. So I think this is what I would say is a methodology by which you can have an efficient system of conducting research. Another topic on which Keshav has asked me to speak a little bit is on management of stress in these times among the professionals. You see, today life has become easy, but it has become very stressful. Now, I know many young people who get stressed out because they're asked to work till 12 o'clock, 1 o'clock in the night every day. Then how do you expect them to be normal? It's not good possible for a human body without adequate rest. So you got to phase yourself in particular way. I still remember as a young lawyer, if I had got delayed in office and returned home after 9 o'clock, next day I would be in for a questioning from my late father. He would say, why did you come so late? Your family is waiting for you. Your children are looking forward to your arrival. What is the use of your coming home after they go to bed? They expect you to be there with them. So you come early. If you want to do some reading, you come back, take your file, get up early in the 5 o'clock in the morning, and you can finish your reading before you go to court. Whereas the need to come home at 10 o'clock, 11 o'clock, that is not the right way to do. So this kind of, home atmosphere is very important. And then you must also have rest and relaxation. Most of the ancient Indian knowledge that we have, unfortunately, has dissipated. It is not part of the education system. The philosophical thought of the Upanishads, of the Vedas, of the commentaries, all of them is not part of us. None of us know it. Unless somebody has particularly been fortunate in being blessed with some teacher who teaches you that, or your home atmosphere is such, you can know it. Otherwise, if you're 24 hours into one profession and you're not thinking of anything other than that, it is a cause for concern. You must develop some pastime. I know many lawyers, they like music. They will attend every single music concert during the Ram Navami. We have a big festival here. At least, 10, 12, 15 days, all leading musicians come and perform. Somebody likes, to act in a play or something. Somebody likes singing. Someone likes to join, social service clubs like Rotary clubs, Lions Club, where you meet a cross section of people. They're not all lawyers and clients. You're meeting a doctor, you're meeting an engineer, you're meeting some industrialist, you're meeting a bureaucrat. All these are in the guise of doing some seva. So Rotary says service above self. So you must serve society. That's how it works. So you may get involved in service organizations. The thing is, the more you get entrenched into your own profession with no option, you are in trouble. And this will slowly have a bearing on you. One important thing which we have all forgotten, maybe a few of us only have been fortunate to practice it, is practice of yoga and pranayama. I started practicing these two things very young in age, and I've continued it after a short break. But then let me tell you, pranayama is something which really relieves you of complete stress. You need to do it only for 20 minutes, 25 minutes a day. You ask yourself a question. Can you not devote 20 or 25 minutes a day for yourself, not for somebody else? This entire thing is for you only. No one else is going to benefit from this. Your mental makeup will be different. Your physiological changes in your body will be different. You will get good sleep. And it's a very simple process. You don't need some great deal of teaching or anything. It's a very, very simple process. If you go to a good guru, you can easily learn the systems. So the methodology of stress management is, one, you have to take a mind off the subject which is occupying most of your time. Second, you have to inculcate certain other things. Now, I have the good or bad habit, I don't know. I'm usually reading 3 to 4 books simultaneously. It's not that I take one book and I read it and finish it and go to the next. I'm currently reading Jeffrey Archer's latest book. And parallelly, I'm reading a book written about some fictional story about some art. Then third, I'm reading, occasionally I read a book which is something to do with the subject. Like, there are books like this, Trial and Error, an Oxford anthology of short stories. These are, actual books which give you interesting talks. And of course, many of you might have read this. Anita Gets Bail by Arun Shourie. Very interesting account of how the legal system works. And more recently, this is a very interesting book by Abhinav Chandrachud, An Independent Colonial Judiciary. Now, the thing is, these are the things which widen your mind. You need not be entrenched into reading only law reports, your own briefs, plaintiff, written statement, objections, appeals, appeal memo, interim applications. Those you have to read because you have to present them in court. But apart from that, one way of taking stress away from you is to read. Now, I want to read you some things from this book. What Shakespeare said about lawyers. Insults for lawyers. All the oldest trades share one distinctive quality. They pride themselves in doing anything for a fee. We know, therefore, that law is an extremely ancient profession, emerging from the dim origins of human experience. A lawyer will complain on demand before, during, or after the fact. Now, there are a number of cartoons also here. One of them shows a lawyer with his robes and his band around his neck and all, and says, his complexion is perfect gallows. I suppose all of you know what gallows means. And in the world's wide mouth, lies scandalized and foully spoken of. That's how the lawyers are referred to. What I'm saying, these are things which have nothing to do with the actual practice of your profession, but it is something to do with the profession, and which are humorous accounts of many things that happen. You have stories about, in fact, I remember an epitaph on a lawyer's gravestone. Says, it was written there, here lies an honest lawyer. Somebody mischievously added there, a rare one indeed. Now, this is how the society is taking pot shots at us. We must know that, and we must make sure that we don't become the object of that ridicule. So I think overall, there is a work-life balance that is very, very important. And you must develop some pastime. Join a club, join a social service organization, join friends who have like-minded people, practice some music or some other form of art. Read, supposing you like philosophy, you want to read the Vedas, you read Upanishads. There are so many illuminating commentaries on Upanishads. You can read them today. You can hear them. There are lectures. Many of them are available. So you have to take your mind away from this. And of course, you have to devote quality time to family. Those of us who have, immediate family like children, grandchildren, it's our duty to give time to them. Especially children when they're young. If you don't give them time when they are young, when they become slightly older, they will not give you time because they don't need you then. But when they have that bonding with you, that is when they are going to feel the same thing towards you. As they grow older, their emotional stability is going to be much better. So I think these are some practical tips which I have implemented in my life. I don't know how many of them are relevant, but all of us should try to do something, because too much of stress is really not a good thing for a good life. You'll get blood pressure, you'll have diabetes, you'll have cancer, and so many other things. You can avoid all of that by these simple methodologies of half an hour of spending on yourself and some good pranayama. I'm sorry, I have to cut short this talk a little bit. I mentioned to Kesha because I have to go for a condolence meeting just after this. So we have a few minutes for questions. Anybody is interested, I would be happy to try and answer them.
So thank you so much. Absolutely. So how do I say? It's really very enlightening just to be able to have the opportunity to observe you also. But I'll keep that aside, and so I'll bring right to the point of what exactly is the relevance of what exactly was the relevance of the class today. So since you're talking about research and the basic research about the faculty, so yourself itself, in the initial period of the class itself, I made the mistake of mentioning the wrong firm. And so again, so that brings me back to exactly this topic and the first question which I want to put to you, sir, in this respect. So that's a since so much is being updated today, so much information is coming across. So how do we figure out which is in case of legal profession, which exactly is probably a recent precedent which has not been overruled or overturned, or maybe if when we are researching online for facts, then which exactly are the updated facts and the correct ones which we can or which we should rely on.
I think there's no choice but to read the decisions. If you're looking at updation of knowledge in terms of case law research, whenever you find a case law, you must search, you must read the decision quickly, you must get to the facts. And then there are tools by which you can find out if this decision in SEC online, you can do this check, whether this decision is referred, deferred, dissented, overruled, followed, or cited in other cases. So that search can be done. So, but then generally, in Supreme Court decisions, they are quite exhaustive in the sense that earlier decisions are always noted. Unless, some occasionally we find that in fact, recently, there's one matter in which I noticed a 3-judge bench dealt with an issue, but did not notice another 3-judge bench judgment earlier, which is laid down the exact opposite view. So this is a rare thing that happens. Otherwise, we have to go through the decision and search and find out dissented and refer to opinions. Another thing is, the importance of being up to date is that this is a constant updation. See, reading a case or doing a research for a particular point is one. Second is reading it for itself, knowledge for knowledge's sake. It's a new development in the law. I don't have any case in that subject, let us say. But there is some very interesting case. Vodafone case came. How many people who are not tax lawyers have read Vodafone? Because Vodafone dealt with number of constitutional issues about what is the power of making law, can they make retrospective law, what is the effect of making retrospective law, imposing a tax. Many of these things. These could be used for other subjects also. So you must have the habit of reading for the sake of reading. Then only that is going to be tucked away at the back of your head somewhere.
So very well put, actually. It brings me to another aspect of another challenge faced by all young lawyers, for that matter of fact, wherein when you start your practice, at that point of time, you get so much variety of cases which come to you. So probably someone starts with the criminal law and then they have to venture into civil law, and that to so many various aspects of civil criminal also. So how exactly would you want to point to them that what should be their approach when handling a new brief of a new case format?
I'll give you a live example of my own case. As soon as I entered the profession, one of my former colleagues who was with me when I was doing my CA, he came to me and said, there's a case of my client. You please appear for him in the magistrate's court. I told him I've not done a single case in magistrate's court. He said, no, it's okay. There'll be other people also you can appear. We are appearing for one of the accused number 5. Others were represented by other counsel. So in my youthful exuberance and ignorance, I went to the Chief Metropolitan Magistrate's Court. And a few minutes later, I saw a lot of people were there. Many people were whispering, he's come from Bombay, he's come here, there, and made inquiries. Mr. Jetmalani's office was appearing for one of the other accused. So 2-3 of his juniors were there. So before I could settle down and ask what was happening, case was called. So then as soon as it was called, they started calling accused 1, 2, 3, 4. Mine was accused number 5. I said, I appear. Judge looked at me and said, are you filing memo of appearance? So I was a bit foxed. I didn't know whether I had wakalat or memo of appearance. Then has he come? He said, no, he's not come. Then where is the application? He said, I didn't know that I had to file an application in the 205 for exemption from appearance. So luckily, another lawyer who was next to me, he said, just tell the judge you're filing application now. Judge will pass it over and keep it because he has to do other things also, guaranteeing bail in other case. So I said, I'll file. So then he taught me how to write it. So I wrote out an application with the memo of appearance and filed it when the case was called. Of course, it went through procedurally, nothing happened. I learned a lesson that day. If I have to go and appear in a case, I will never ever go and make a mistake of not understanding, not reading, not asking. Go to seniors, ask them, when you're sitting in the bar room or in the high court, many lawyers come and ask us, sir, I have this problem. What should I do? Of course, we all, guide them, whatever we know, knowledge, information we share with them. So the advice I would give is, don't take anything for granted or lightly. If you get a new subject, before you accept the brief, please go through and study it. In fact, one of the judges who retired from Supreme Court, one day he called me when he was in the High Court. He said, hey, yaar, mere ko ye company law de diya. I've never done a company law case in my whole career as a lawyer. How do I sit as company judge? You have to help me. I said, what do you want me to do? He said, give me a list of 20 leading cases on every jurisdiction which comes before the High Court in company side. Each subject, give me at least 2-3 leading decisions, High Court, Supreme Court, whatever it is. And then I gave him a list. To his credit, in hardly a few days' time, he read all those decisions, mastered everything, and he became such a popular judge on company side. Nobody realized that the man had not done a single case as a lawyer in company side. How did he become like that? By industry, by interest, by having to understand. Then only you can decide. No? Same judge, when he went to Supreme Court, suddenly he told me one day, criminal case de diya yaar, criminal appeals. I've not done a single criminal appeal. I told Chief, Baba, please, take me out of criminal roster. Give me some other subject. Chief told him, brother, you sit with me for 1-2 days. There's nothing in criminal side. You have got to go to the facts, that's all. After that, he sat on criminal side and his leading judgments are leading decisions today. So what I'm saying is that it depends on how we get ready. Na? You have to go to battle. Even if somebody gives you a gun, if you don't know how to, shoot with it, what is the use? So that's our effort.
So it's actually fantastic, sir, what you just said. It makes so much sense that it's a battle at the end of the day and you have to be prepared for war. Circumstances, you have to fight. I think, sir, again, sir, you mentioned very explicitly also, sir, that you have to go and appear for a very personal function for you. So in that respect, just one final question I will limit myself to, and then if there is any question which anyone wants to ask, we'll just very briefly take that. So that is with respect to differentiating between news and fake news. That today, sir, it's a very big challenge, and I'm sure that everyone's aware. So what are your opinions and what are your views of how to differentiate between?
No, you see, so far as the practice of our profession is concerned, we are neither concerned with news nor fake news. We don't take any decision or advise client based on news. We look at the facts of the case. And if there's a law, we study the law. Now, news and fake news is something which the client has to satisfy himself or herself about it. So we don't take any call on that. So I think, we have to just hear it and say, I'm not sure about it. But we don't advise clients on news. So I don't think as lawyers, we should be too much worried as to whether something which is said is true or no. Sometimes, they say some decision of the Supreme Court is there. So if somebody says that, you must look at the decision, get the order, read it, and then go by it.
Absolutely. So again, these are the kind of things. So because again, so you mentioned Indian traditional knowledge systems, and one very interesting thing which I got to know from there was that knowledge dispels all fears. So thank you so much for helping us dispel our fears today. And so it was absolutely enlightening and very refreshing. So you even mentioned Chat GPT, and it made me think about what exactly is the future of law and drafting. It's a very limited time. If you want to shed some light on that, otherwise, I would really, it will be great if you can have another occasion to discuss technology law with us and how technology is evolving and shaping law.
Yeah. Okay, I think in terms of drafting, I think there is a marked difference between drafting in North India and South India. In South India, plaints are usually, unless a very complicated case, is about 4 or 5 pages. In Bombay, it is minimum 50 pages. Delhi, it is 50 and 75 pages. So the same thing is repeated and repeated and repeated. And they don't even use proper grammar. Every sentence they begin with the word because. I was taught in school that you can never start a word with the word because, any paragraph, any sentence. But all of them do that. I don't know why they do that. What is that system? So in the South, if you go, I've seen plaints which are only 1.5 page plaint. That's all. Suit for specific performance, 1.5 pages. That's all is to be. Whatever is to be pleaded is pleaded. Nothing else. So conciseness and preciseness is, I think, what is important. You have to develop that art of writing precisely and crisply. What you can say in 2 lines, don't say it in 10 lines. That's the thing. Same thing with pleadings also, drafting of pleadings, drafting of documentation. You need to be precise, you need to be clear, and you need to know what is it that you want to say. The minute you are clear about that, the language will come all right. But if you are confused, or if you want to confuse somebody, then you can be verbose.
Absolutely amazing, sir. I am just, my mind is right now, it's actually working overtime. It's like a Monday for me, not a Sunday anymore. So thank you so much. Well, just one finally, so I'll ask everyone if there is any question which anyone wants to put across to sir. It's a very good time. All right, so we'll work out with the.
If there are no questions, it means they didn't understand anything or they didn't have any doubts.
So
I
they're
think
reluctant. So they're reluctant.
No, sir.
Reluctant.
No, sir. It is really an amazing experience to listen you speak so well that I'm really amazing here. It's amazing experience for us to hear you, and I hope we will hear you soon again.
Thank you.
So many people are saying thank you and congratulations. And so again, many thanks to you, sir. But I'll just say one more thing. So 2 topics have come to my mind, which I think we need more enlightenment from you on. One is drafting. So the idea of 1.5 page draft, and sir, absolutely perfect when you mentioned that there are relatively lengthier briefs in whatever differences you've been able to mention between all the North India, South India drafting and all. So with respect to that, whatever these crisp and short briefs are there and drafts are there, so it would be really amazing if you can shed some light maybe in the near future for us in that respect. Along with that, sir, what exactly are your views on technology? Because you're aware with Chat GPT and you're aware up to date with all of these things. I've seen all of our seniors are. So it would be really wonderful to probably in the future have your thoughts on these things also at some point.
Okay, we'll have a session. Try to get this guy, what's his name? Rahul Matan.
Okay.
He's a founding partner of Trilegal, and they do quite a large volume of litigation and advisory work in technology law. He also writes a column in the Mint newspaper. It's very fine. So I think if you want him to talk, it would be good.
Absolutely, sir. We'll keep that in mind. And with that, sir, very, very deep thanks to you and very humble gratitude on behalf of all of our participants. Thank you, everyone who has joined, anyone who has seen this video on YouTube. So now, with your blessing, today we are also on YouTube and we're doing this live. So thank you to you, sir, very much. And anyone who's watching, please like, share, subscribe. Now we can officially say that. Thanks
Thanks,
so much.
and bye. Have a